This video is sponsored by Wonderleaf Occlusive Dressings.
Okay, so you've just been sued. You peer through the documents that you've just been handed. You see a document that has your name, writ, and statement of claim complete with a Malaysian coat of arms on it. Yup, you've definitely just been sued.
First of all, don't worry. You are not alone. Many healthcare professionals have had a similar experience. It is not the end of the world, but it is also not a small matter. Lawsuits can last anywhere from a few months to over a year and will require some commitment on your end.
Maybe you've tried settling the matter with the patient before this, maybe you've already notified your insurer, but for now, we'll assume none of that has happened and this is taking you by surprise now.
Okay, one step at a time. Depending on your insurance contract, you might want to start by notifying your indemnity insurer. Other than the fact that it is usually your duty to inform them of claims made against you, notifying them late may cause them to miss the court deadlines and may reduce their chances at negotiating a settlement earlier. If you are worried about your premiums for the next year, you should seek professional advice.
A quick note on mental health here, it's important to seek professional help if you're feeling down. You're probably worrying about your reputation or whether people will be talking about your stuff up for many years to come, but it is our experience that people forget and many cases are settled out of court before they even reach trial.
Once you refer the case to the insurer's lawyer will be in touch with you. Be prepared to work with them and provide them with relevant documents. It is important to be honest with them, just as you expect your patients to be completely honest with you. Don't worry, your communications with your lawyer are protected under legal professional privilege, which means it is kept very, very secret.
For now, we'll just assume the insurance company accepts your claim. We'll talk about different types of insurance and what happens if the insurance company rejects your claim in a separate video. Right now, let's have a look at what happens on the insurance lawyer's side.
First, a lawyer will look at the limitation period. A living patient has 3 years from the date of injury to sue if they are suing in Sabah and Sarawak, and 6 years if they are suing in West Malaysia. For deceased patients, their estate has 3 years from the date the patient passes away. If they sue outside these time limitations, their claim might fail.
Alright, the next thing a lawyer will do is file a notice of appearance. This lets the court know who the lawyer on record is and that you intend to defend yourself. They usually have around 14 days from the date you receive the statement of claim to do this, so it's really important not to sit on a statement of claim for too long. After this, you have another 14 days to submit a defense.
This involves going through the statement of claim and going through point by point. The statement of claim is basically just a list of allegations against you. Your lawyer might ask you to give your views as to each point.
In the statement of claim, the patient must show 3 things. 1. How you've fallen short of your standard of care. 2. How such negligence has caused their current damage. And 3. They have to quantify their current damage. To learn more about your standard of care, watch our Zulhasnimar video, and to learn more about causation and damages, we'll be making a future video about it, so remember to subscribe.
Once the defense has been filed, the patient might make further allegations and has 14 days to do so. Once this is done, the court will set deadlines for when the parties must compile and exchange evidence and confirm the witnesses to be called. Your lawyer might engage another healthcare professional to give their expert opinion, saying whether you comply or deviated from the standard of care. Once this process is complete, the trial date will be set. The trial date is the day everyone appears in the courtroom with the judge, like what you see in the movies.
The case can be settled out of court between the parties at any point in these proceedings. Your insurance company will likely try their best to settle the case because trials usually carry some level of risk. The insurance company will usually calculate the estimated payout against the level of risk and negotiate with the patient for a payout on a non-admission of liability basis, meaning the patient can't go around telling the public you did something wrong, thereby protecting your reputation.
If the parties cannot agree to a settlement sum or are convinced their argument is correct, the case will go for trial. The trial will usually last a few days, and your lawyer will usually tell you what to expect for trial, but is not allowed to coach you or train you to answer the questions.
At trial, the parties will call upon their own witnesses to testify and produce the documents or evidence. After that, the opposing party's lawyer will cross-examine the witnesses. If you've ever seen legal dramas, this is where the lawyer asks yes or no questions and tries to discredit the witness. After the cross-examination, the witness can be re-examined to explain what he or she said during the cross-examination.
Once this process is complete, the trial is over. In legal dramas, you may have seen the judge delivering the result immediately after the lawyers deliver an emotional closing statement. That basically never happens. After the trial, the parties will be given 1 or 2 months to file and exchange written submissions. The court will usually deliver its judgment 1 to 3 months after it receives the submissions.
If the patient wins, the court may ask you to pay money to the patient. This amount is based on the addition of unquantifiable losses like pain and suffering, otherwise known as general damages, and quantifiable loss like medical bills and lost wages, also known as special damages.
In very rare circumstances, the court can ask you to pay aggravated damages and punitive damages. Aggravated damages are payments to the patient to compensate them for putting them in humiliating or malicious circumstances. Punitive damages translates loosely into punishment money. It is payable when the court finds the health professional's conduct so bad it feels the need to punish them. So, in brief, your payout is the addition of special damages, general damages, aggravated damages, punitive damages, and the patient's legal fees. We will be doing a whole separate video on payouts, so remember to subscribe.
If you win, great! The court may ask the patient to pay your legal fees and disbursements thereto. Unfortunately, it is highly unlikely you'll be compensated for time lost on case preparation or the mental anguish you had to undergo. If it's any consolation, your case will be a warning to all patients in the future in a similar situation.
So, that was a very brief overview of the civil procedure process. We have left out a lot of detail, so this video should not be a replacement to seeking professional legal advice. If you are being sued, you should always speak to a licensed legal professional.
Absolutely. Please don't sue us.
If you enjoyed this video and want to find out more, remember to like and subscribe.
Thanks, and we'll see you in the next video.